Awesome. So today, everybody, you need to be on the classroom page, and specifically, you need to be on the classwork part of the Google Classroom page for workplace law. We are looking at the Unit 3 summative, specifically two things, two main parts of your summative, and that's the opening statement if you are a lawyer, which I don't think we have any lawyers in here today, which is interesting. So most of you are going to do the mock trial role description, but we are all learning how exactly to do an opening statement. So if you don't already, which I haven't handed them out yet, come on up here and grab yourself a mock trial opening statement worksheet. There you go. Good. So if you are a lawyer, you will need a good copy of one of these. You'll need to submit one of those. If you're not a lawyer, you can just do a rough copy of them today so you understand how an opening statement works, which is a key part of one of our learning goals for this unit. There's also some learning goals that you're going to need to put on your coursework document. So you can go ahead and open your coursework document right now. And there are two learning goals that you can put on your coursework document or that you need to. And they're here. You can copy and paste those. So if you click on this and you open up your coursework doc in another tab, you can quite simply just go ahead and copy and paste those two learning goals from the mock trial onto your coursework doc. So I'll go through that one more time. It's Unit 3, and we're now into the mock trial. You've got two learning goals for that. So I've added a heading to my coursework doc. And you're going to put the two learning goals that were at the very top of the mock trial summative page here. Let's take these guys. And you're going to put these The learning goals are important because they help you determine whether or not you understand completely what you're doing and why you're doing it. So give me a thumbs up out there if you remember what actus reus means. Actus reus, anybody? Okay. How about mens rea? Okay, give me a thumbs up if you think actus reus is the physical act of the crime. Give me a thumbs up if you think mens rea means a person's mind or intent. There you go, then you're correct. It's those two things, mens mind, actus physical act. That's how you remember those two. That was our quick review. Nicely done. So for a person to be guilty in a trial, beyond a reasonable doubt, those two requirements need to be proven by someone called the Crown Attorney. The Crown Attorney is the person who represents the Queen or the R in the information in a case. Also represents us, society, Canadian citizens, and so on. So that goes on to learning goal number 2 there, which is I can describe the roles of key participants in a criminal trial, defense counsel in relation to the steps in a criminal trial process. So we're going to possibly start to work on the opening statement today. But if you have those two learning goals on your coursework document, that's a good start. You can keep the coursework document open because you can add some items to that after. The next piece that I need to show you today is also on the classroom page under the mock trial Unit 3 summative topic. Right below where it says mock trial learning goals. So now you need to go back to classroom and click on classwork if you're not already there. And if you click on Introduction to Criminal Trials, you're going to need to open this document, but don't just click on it because it'll kick the tab away for the classroom. You want to right click on this document and say open in a new tab. So on a Chromebook, 2 fingers. If you don't have a mouse attached, 2 fingers on the trackpad. And if you have a mouse, it's a right click and then open link in a new tab. Here. Once you've done that, I need you to open this up with Read and Write for Google Chrome. Because we are going to use a study tool today. We're going to use the highlight study tool today to pull out some important information about criminal trials and to show you how you can use that study tool to collect key information and put that on a Google Doc so you can study it for later, or you can place it on your coursework document. All right, so around the classroom, give me a thumbs up when you've opened up this document and you are ready to go. Okay. Okay, so just watch then, Jack, for now. We'll do all that stuff after. It just means you haven't installed it yet. Okay. Dylan, thumbs up. Okay, so go to the very top and click on Open with Google Read and Write for Google Chrome. Anybody who just walked in, you can just follow along. Come close if you need to. Scooch over the beanbag. Don't worry about it. Just watch for now. If you get a prompt that says install now, you need to go through about 5 to 6 steps to install it and get it working. We won't do that right now, but I can show you all afterwards how to go through those steps. If you have this open in Read and Write for Google Chrome, does anybody have this open? Read and Write for Google Chrome? Anybody at all? Okay, no problem. Then I'll just show you how to do highlights. And you can watch this video afterwards once we have everything else sorted out. So the first thing that I'll get you to do today is I'll get you to highlight this first paragraph, it's called here. This tells about the Crown attorneys. The Crown attorneys, the people I was just talking about. What you would do here is you'd use something called the highlighting tool, which is this. It's going to drop down and give you a number of colors. So when it comes to this, you can pick all one color because we know this is all for a criminal trial. If it were a few different subjects or topics, you could use different highlight tools. Piper, you might already know how to use the highlighting tool. Awesome. So this will be a review for you, which is great, and you can help some other folks once we get it all caught up. So today, because I'm colorblind and I can tell yellow the best out of all these other colors, I'm going to pick yellow. So I'm going to highlight that. And that tells me about the Crown attorney or the assistant Crown attorney, the person I just talked about. The next part is that I'm going to get you to highlight what exactly constitutes or what is a criminal offense in Canada, which is this here. And I'm going to highlight that entire paragraph because it gives me a good amount of detail. We are doing a criminal trial in our class. We are dealing with a someone charged under the Youth Criminal Justice Act as well. And we talked about summary convictions and we talked about indictable offenses as well. And what we have is theft under $5,000, which we determined on Friday, I believe, was a summary conviction, right? The judge could put a person in jail for over 2 years, but in our case, Carrie Jones had never offended before, and there were a number of different circumstances about that. Alrighty. So here. The next is that you're looking at the crime itself, which is this. So it says here the Crown has to prove in order for the accused to be found guilty. The defense does not have to prove that a person is not guilty. The defense does not have to prove that. They only have to poke holes in either the intent or the act itself. So if we're looking at the Carrie Jones case, did she walk out of the store with the MyPod shuffler attached to her belt? That we know. But are we 100% clear that she meant to? That she had the intent of taking it? No, we aren't. There's not enough evidence there. So what the defense has to do is poke holes in the Crown Attorney's case, and the Crown Attorney has to prove what's called beyond a reasonable doubt. A reasonable doubt that the crime fits both mens rea and actus reus. Here. And today on that opening statement handout, you're going to fill out those definitions again. And Piper, you'll need this because you are one of the lawyers. So you're going to need to do that anyway. Okay, here, a trial is a kind of debate between two groups called parties. Parties. One being the accused and the people who represent them, and the other party being the Crown. What I would like you to do is I would like you to, underneath those two learning goals in your coursework document, which is still open, I'd like you to type in the word adversarial. And I'll put it up here for you so you can see it. I'll try to make it nice and big. Adversarial. That's the type of system that we have in Canada. Is called an adversarial system. There. Okay. Take a second. Type that in your coursework document. Adversarial. Adversarial means there's two adversaries going against each other. So anytime a situation gets into a courtroom or a tribunal area, we have an adversarial system. Remember when we did the mediation exercise where I talked about it's two enemies going against each other. And that's why in that game you had the option to fight, right? You had the option of battle, and that's an adversarial situation. It's not two people sitting down and talking and trying to solve something. You fight about it. You fight about it. But it's not up to you what the outcome is. That's the adversarial system. Most lawyers never want to go to court. They never want to go to court. They want to sit down with the other lawyer and settle it out of court because trials cost money, trials cost time. And anybody who's running their own business, including lawyers, want to save that money. Crown attorneys want to save that money so they're not having taxpayers pay for those huge trials, for the time to the judge to be there, for people to be taken out to sit on juries to decide on this, and so on. Your next important point about a trial is that every person who's charged with an offense is innocent until proven guilty and has the right to a trial. And as I said before, there has to be beyond a reasonable doubt proof that both mens rea and actus reus were satisfied. So to the highest standard of proof, no doubt whatsoever. Okay. Next, we have something called the arraignment or the plea that happens first. That's where a person stands and the judge says, how do you plead? And the person says guilty or not guilty. If they plead guilty, they go on to something called a sentencing hearing. If they plead not guilty, then the trial starts. And the trial starts. So if you think about it in the way of the flow chart that we did, the criminal process flow chart, you're going to be doing a flow chart also for the trial with all the different parts in it. Okay. All the rest down here in this document, I'm not going to go through right now because we will be looking at this another time. So this is your basic pieces about the trial itself and how that goes to trial and your charges and burden of proof and so on and the roles for each side. So what you do now, once you have your highlights highlighted, is you click on collect highlights here and it asks you which highlights you want to be collected. Since I only have yellow, I'm going to choose yellow. And I'm going to click OK. And what that does is it creates a new Google Doc that has all my highlighted notes in it. So I don't have to type things down again. I don't have to copy and paste anything. It's done for me already. And instead of just being called PDF highlights, I'm going to call this introduction to trial process, and it's criminal. There we go. So now I have this document, which is an introduction to the trial process. If I want, I can take all of these highlights now by hitting Control and the letter A and Control and the letter C, putting this on my coursework document. Just like that. I've already taken the notes using the highlight tool, and I know because it's yellow, it's associated to the introduction to the trial process. So I'm going to go over here, and I'm going to put this under trial. Now, the cool thing about this is when you take notes like this, it also gives you a link to the document that you originally got it from. So you can go back to that if you need to get some more information. There you go. Alrighty. Good stuff? Okay. Great. I think for now, that's probably enough. I don't think I'm going to put any more on you for today because we're going to be moving on to the role description. And Piper, you and I can talk about the opening statement. Alrighty. Good. In that case, I'm going to change the name of this video because it's not about the opening statement or the role description. It's an introduction in this case. And thank you very much for your listening. You guys were a great audience. I accept rounds of applause. Okay. Yeah. By the way, I brought donuts and muffins and all that for the people that were here on Friday. Yeah, that's better. Okay. Great. Okay. Thanks for listening, everybody. And we will talk to you soon.